Welcome to the NSCHBC Edge Podcast, leading the way in the business of medicine. Now here's your host, Terry Fletcher.
Hello, everyone, and welcome to the NSCHBC Edge Podcast. I'm your host, Terry Fletcher. The Edge Podcast is brought to you today by the National Society of Certified Healthcare Business Consultants. Our goal is to discuss healthy business principles, have conversations on the business side of medicine, so that you and your practice can thrive, be profitable, and successful for years to come. Today we focus on employee termination scenarios, which we all know can be stressful, but are you following the rules and are you legally covered? Tackling those topics with me today is Amanda Weish, who operates a national healthcare practice and is licensed in both Ohio and Florida. She primarily focuses her practice on healthcare, employment law, corporate law, and healthcare litigation, and advises all types of employers, in particular healthcare providers, including hospitals and physicians, on various matters. Also, Brian Meek, who is an attorney at BMD's Health Law Department and Labor and Employment Department. Brian counsels a wide variety of health industry clients on issues such as contract disputes, government and private payer appeals and disputes, including audits, administrative appeals and negotiations, compliance plans, credentialing, certification, board investigations and suspensions, and fraud and abuse disputes. For those matters which warrant formal litigation, Brian assists clients with filing or otherwise defending complaints in court or before an arbitrator. Amanda and Brian, welcome to the podcast.
Thank you so much, Terry. Thanks for having us today.
Yes, thank you, Terry. Excited to be here.
So our topic for discussion today is actually, I think this is going to be just such a great way to present, is instead of just listeners, for you that sometimes listen into a podcast and you think maybe we're talking at you and not necessarily with you or to you, what Amanda and Brian are going to do is they're going to do role playing, and they're going to give us some employee termination scenarios, and really looking at what you need to do prior to terminating an employee. You know, for example, should there be a probationary period, a possible suspension, maybe a sanction rather than a termination, and should there be maybe a final warning? But looking at these employment policies as well when making these termination or discipline decisions, there really should be some kind of a back and forth. And what does an employer really need to do to be able to get the ball rolling on that? So we're going to go ahead and allow Amanda and Brian just to kind of give us a scenario and a couple of scenarios of how that happens. So go ahead and take it away.
Thanks, Terry. You know, this is a question that we're asked so often as legal counsel. What type of discipline should I impose on my employee? And we get these calls typically 4 o'clock on a Friday afternoon, and we seem to be giving, the same advice all the time. Make sure that you follow your policy. We advise that all employers have an employee handbook, that all employers have what's called a progressive discipline policy. So as you mentioned, that would include a, verbal warning, a written warning, possibly probation, suspension, a final written warning up to termination. And so that's, a progressive discipline policy. And the infraction or the issue at hand will really be determinant of what type of discipline you impose as the employer. So, the first thing that we always advise our employers is, do you have a policy? You want to make sure you follow that policy. And then also you want to be consistent. So you want to impose the same type of discipline for similar infractions in your company. So you want to be consistent as an employer. The second question that we always get is, well, if I need to terminate someone, how do I do it? What do I say? Oftentimes employers cannot anticipate how an employee is going to react. And so we often find ourselves writing scripts for our employer clients. If this, then that. This is what you say if the employee reacts this way. And so what Brian and I have started to do in our training for our employer clients is do role playing. It's a fun way to train our clients, but it also gives them some real life scenarios and some key takeaways rather than seeing a written script or feverishly writing something down quickly at 4 o'clock on a Friday afternoon before they terminate someone. So we want to walk through just some common scenarios, and we hope that you find this not only educational, but also fun as well.
That sounds great. And Brian, we're going to also hand it over to you for any additional remarks before you guys get started. I think real quick, one of the things that you brought up is how many employers like to do this at 4 o'clock on a Friday. So hopefully that'll be part of your conversation.
Exactly,
Absolutely.
Terry. Yeah, absolutely, Terry. So the time to begin having the discussion and thinking about whether to terminate an employee should start well before, Friday at 4 o'clock, as Amanda said. Selfishly, it makes our lives a little easier, number one. Number two, it also allows, us and our clients to kind of think through all the issues and, to allow them to see all sides of the scenario, help prepare them for the termination scenario if that's the route they want to go, or otherwise talk about some other legal pitfalls they may be walking into when evaluating, just discipline versus termination. So just kind of segue into our first termination scenario here that Amanda and I are going to act out and to kind of set the scene for the crowd. I will be serving as Amanda's supervisor today, and I'll be the one conducting the termination. This first scenario that we're going to cover is just going to kind of be your standard termination situation. This kind of sets the bar of how we like terminations to go. It's just kind of easy. It's going to be an easy conversation. It's just going to, everyone at the end, is okay with the decision type of termination scenario. So with that being said, I think we're just going to go ahead and jump right on in here. Thank you for coming in today, Amanda. Please have a seat. The reason Tracy and I scheduled this meeting is because Brennan, Manna, and Diamond is terminating your employment effective today.
Wait, what? Why, Brian? I just don't understand. Did I do something wrong?
Amanda, I understand that this is hard news to hear. I will say that, as you know, you have been on a performance improvement plan for the last 3 months as a result of inadequate work product that simply did not rise to our expectations for you. At the conclusion of this 3-month period, we did re-review your performance over the last couple of months in sufficient detail, and we decided that it is now time that we end this employment relationship.
Well, I understand. I thought that this was coming. Well, wait a minute. Are you able to give me at least one more chance? I promise I can improve.
Unfortunately, we do need to terminate the relationship at this time. We did give you the 3 months to improve after our prior discussion, and we reminded you periodically during the last 3 months that there was continued performance issues. However, in recognition for your length of employment with us, BMD is willing to offer you a severance package. I'm going to hand it to you now. This also contains the information on future employer references and how those will be handled, and it should answer some other additional questions you may have.
Thank you. I'm just so surprised. I'm just so taken aback. I appreciate your kindness. Before I sign this, can I review this with my husband first?
Absolutely. I recommend that you take it home and review it. If you are accepting of the terms that are in the document, please sign and return it to me simply within 21 days. You may email me your signature. However, I do ask that before you leave here today, are you willing to sign the acknowledgement of receipt that's at the bottom of the severance agreement? The signature does not mean that you're agreeing to the terms of what's inside the agreement. It only means that you have received this package.
Yes, I can do that for you.
Thank you, Amanda. And I'm really sorry that this relationship could not work out, and we wish you success in all of your future endeavors. At this time, I am going to conclude this meeting, and I ask that you return to your desk with Tracy so you can collect your personal belongings and return your key card.
Thank you, Brian. I really enjoyed working here. I'll email you my signature after I review the documents with my husband. Thank you.
So thanks, Amanda. That was great. And we have a couple notes, Terry, to kind of wrap up the scenario and just some of the key takeaways that come from this first scenario.
Sure. And one of the things that I thought was interesting in what she said, you are going to have to deal sometimes with an upset employee, and being even keeled as an employer is really going to be a key to finishing. I hate to say finishing the job, but really just keeping in line with what your task is, if that is your role. So can you talk about that?
Sure. So what you couldn't see, Terry, is that I was crying. And that, tears streaming down my face, maybe I needed tissues. And that can be really unnerving for the employer, especially if they're uncomfortable in this scenario and they don't do it very often. I know that as attorneys, sometimes we get very hardened to these situations because we deal with them. Doesn't mean that we are not emotional or that we're not sympathetic or empathetic to the situation. It's just that we deal with them more often, and so we can kind of compartmentalize. So it's really important for the employer to prepare for that and to be prepared with their talking points so that they're not emotionally, dragged in a different direction. But so it is important that the employer gets all of their talking points out. But is primarily unsympathetic. You want to be laser focused, on point, and direct with your messaging, and also consistent with your messaging. And this will help you move through the conversation and prevent any kind of debate regarding the termination. So remember, Brian kept circling back to, now remember, you were on a performance improvement plan. Remember, we reviewed this with you. And so he did not debate when I asked for one more chance or that I could do better. He stuck to the point.
And I did like that. I thought that was really noticeable in your exchange. I think that one of the things that's really hard, especially in healthcare and with everything that's going on, especially now with the pandemic, is really sticking to business and not making it personal, making it more about a business decision.
Right. Absolutely. Brian, when you terminated me, you had Tracy in the room. Do you want to explain why Tracy was in the room and why she helped me gather my belongings?
Yes, absolutely. So one of the pieces of advice that we always give to our clients is that you have at least two people in the room when conducting the termination. It helps to establish a witness in the unfortunate event of a lawsuit or issue down the road. And taking that a step further, we also recommend that you have one person of the same gender as the person being terminated. Again, that just helps to alleviate any questions or concerns that could arise down the road in the event of a lawsuit or potential issue. Also, I asked Tracy to follow Amanda back to her desk to help her collect her belongings. And again, the key for that is just to keep that same gendered individual, kind of with her and escorting her through the building and, ensuring that she gets out of the building safely. And isn't causing a disruption or things like that. So just having two people present is just really a best practice for all terminations.
I have a question with regard to, now that technology is so high, what about any kind of employee that would want to record the meeting, or if the employer would want to record the meeting? First of all, as attorneys, do you recommend that an employer does that? And do you allow that for the employee?
That's a great question, Terry, and we're actually going to get into that in our second scenario a little bit. So just kind of that's a foreshadowing, but
perfect.
Yeah. So, but just kind of in response to your question, we typically do not advise that our employers record the meetings with employees. It can kind of set the stage of making things a little bit divisive. And, there's a lot of states out there that require multiple parties to consent to recording. So they shouldn't really undertake a secret recording scenario either. Now, as we'll get into in that second scenario, if an employee requests to record the conversation, you don't necessarily object to that. Go ahead and go along with it, but then just we advise our clients that, hey, you just got to remember that you are being recorded, and, you need to keep everything you say surface level, direct, and to the point, which is kind of one of our main principles of today is when conducting terminations, keep things straightforward, direct, and to the point.
That sounds great. Well, so that's a great lead in for your next scenario. So let's see how you're doing with the next one. I'm ready for that one.
kind of setting the stage for this next termination. This is going to be a bit more on the aggressive side, just to kind of illustrate, how we hope most terminations don't go. But, in the event that you do have an aggressive termination, here's how you would resolve that situation. So I'm just going to start the scene now. Thank you for coming in today, Amanda. Please have a seat. The reason John and I scheduled this meeting is because Brennan, Manna, and Diamond is terminating your employment effective today.
What? Yeah, that's not happening. You know this company can't make it without me, and it will completely fall apart without my skill and knowledge. You have zero legitimate reasons to terminate me, and I'm not leaving.
I know this is hard news to hear. As you know, we have warned you multiple times about arriving late to work. And just today, without any prior phone call or warning to us, you showed up 4 hours late. So why were you late today?
That is absolutely none of your business. You are terminating me solely because I'm a woman, aren't you? I'm going to sue this company for everything it's worth. And without me, it's not worth very much. And I'm going to write the meanest Yelp reviews you have ever seen.
Again, I certainly understand your frustration with this decision. However, we cannot evaluate whether to excuse your absence today unless you tell us why you were late. And in accordance with our progressive discipline policy, this absence today would equal a termination.
I'm not telling you anything. I don't have to. Like I said, you are only terminating me because I'm a woman. You know for a fact that Jack is late like multiple days per week, and he is never fired. You are getting sued.
We are not here to have a debate, and I do not agree with your recitation of the circumstances of other employees. Your termination has been reviewed on its merits, and the decision has been made. At this time, given your legal threats and completely unruly behavior, I'm going to conclude this meeting. I ask that you immediately return to your desk with Tracy to collect your personal belongings, return your key card, and exit the building. Are you willing to do that?
Absolutely not. I am not leaving this room until you tell me why you are discriminating against me for being a woman. In fact, I'm going to start recording this conversation so that I can give it to my lawyer.
Amanda, you have been very unruly and disruptive during this entire conversation and have made wrong statements of fact and accused other employees of misconduct that is simply not true. Therefore, as I've indicated, I am concluding this meeting. You are now trespassing and need to leave the office building immediately.
I'm not going anywhere, Brian, and you can't make me leave.
If you're going to continue to refuse to leave, I'm going to have to call the police.
Go ahead, call them. I'm sure they would love to hear all about your discrimination.
I am sorry, but you have left me no choice. Tracy, please use my phone to call the police and let them know there is an unruly ex-employee on the premise who is refusing to leave the building. She is now trespassing.
Fine. Have it your way. I'm leaving. Forget you. I hate this place anyway, but you better watch out for that Yelp review and my lawsuit because it's coming your way.
Thanks again for your, yeah.
I'm trying not to laugh here, but this is awesome. And I'm laughing with our listeners, just so you know. I think that's great. Amanda, you play this role a little too well. That's all I'm saying. But so in follow up to that, I think it's a great reason to really, this to me was like a deja vu of what I've been told by a lot of office managers, that this actually happens and it does get hostile. And, please expand on that, Brian, as far as, would you actually call the police? And what do you do at this point? Do you actually think that employee would take legal action, and do you act like they will?
Those are both great follow-up questions. First, would I actually call the police if after I've asked them to leave and they still were not leaving, and I've indicated, hey, you're now trespassing, and I have instructed somebody to call the police? At that point, if they continue to stay, then yes, I'm going to have that person that's in the room with me, because again, you always have two people. I'm going to have that person go through with the call. However, if they immediately stand up and say, hey, fine, I'm turning around, I'm leaving, then, I'm going to go ahead and hang up that call. If in some circumstances, if going into the meeting, you're going to have an unruly employee, or you suspect it's going to be unruly, you can have security or police on standby. I would never recommend that you have them actually in the termination room, just kind of out of sight, out of mind, but at least, they're in the parking lot or in another part of the building. in case an issue did arise, that they're right there and ready to assist.
Okay, and I really like the fact that during the back and forth, you said at this point you were trespassing when she refused to leave, because now you have a legal position. Is that correct?
Yeah, that's correct. We have put this employee on notice that, hey, we are considering you to be a trespasser, and for that reason, we could involve the police if we felt the need to do so.
Well, I think this was just really a great, from a simple termination to a hostile one where what do you do? And I think Amanda actually brought up a really good point when it comes to somebody making the assumption that the termination was for something other than what they were being terminated for. Which one thing I was thinking about when you said that, and I think you sent over some talking points for me. When you're dealing with somebody that is that hostile and you're anticipating that could happen, what do you do to protect yourself as an employer? Because if the employee falls into any protected class, age, sex, religion, disability, etc., how is that going to affect your termination process? Because this person basically insinuated that it was, an issue, a gender issue, which clearly it wasn't. It was about, her work. But how do you make sure that that doesn't happen, or that isn't the problem?
That's a great question, Terry. In response, how we obviously, gender, protected classes, race, none of those things can ever be an issue in termination, nor should they ever be an issue in termination. And obviously termination decisions should never be based on those characteristics. However, when you are looking at a termination and helping an employer, analyze their risks and benefits with termination, because of certain legal statuses that come along with those characteristics, we do have to ask those questions. And the only reason we're asking those questions is to make sure that we are treating everybody equal. Meaning, so if somebody says, well, we're intending on terminating an employee today who is a 55-year-old woman who falls into two protected classes there, they're protected under age discrimination, and they're protected as a woman as well. I'm going to say to our employer client, hey, the reason that you're terminating her, have you terminated men for that same reason? Have you terminated young people for that same reason? Or have you just given them warnings? We have to make sure that when I ask those characteristic questions, it's to ensure that everyone is being treated equal, because we don't want to have a situation where, in this case, in particular, they are being treated unequal, and we want to stop that before that unequal treatment occurs.
That's awesome. No, I appreciate that information. I think that one thing in the climate of making sure that there is equity when it comes to employment and everything we're doing out there with minorities, I know that this becomes an issue at times, especially when it is not I'm not sure how to word it, but let's just say a minority heavy employer, where maybe it's 50% Caucasian and then the other 50% is mixed, different races, and somebody needs to be terminated, that maybe you have one or two either African American or Hispanic or Asian employees, that maybe one needs to be terminated, but it doesn't seem like to that individual that somebody of a different race is being terminated as well on the same stature. So I think that there's some sensitivity and issues there that are on a larger scale.
Yeah, you're so right, Terry. And that goes back to our comments at the beginning, is we want to make sure that we're following your written policies and we're following the past practices of the employer, so that we don't end up in that situation where we are either purposefully or maybe inadvertently treating people differently and not realizing it. And so that's why we ask the employers that question. And your point is well taken. One of the most common types of lawsuits are employment claims, whether it's, wrongful discharge or discrimination or harassment. These are the most commonly litigated types of issues that we see. And they're definitely on the rise this year in 2020 because we've had so many terminations, largely due to COVID. And now with the FFCRA, not that we're going to get into that, but that just adds another layer or another set of rules that employers need to abide by. And that's just another tool in a litigator's pocket, when they're litigating on behalf of a terminated employee. And so employers, we're cognizant of the fact that they're navigating a very tumultuous environment right now. And there is just, there's a lot of things that they, rightfully need to worry about. And so, so we want to make sure that they do have the policies, they do have the documentation, and that they prepare for these hard conversations and these hard decisions.
Yeah, I agree.
Now,
and I have a question real quick. You mentioned an acronym, and the audience may not know what that is. Can you just, without expanding on what it is, can you just spell it out for us?
Yeah, the FFCRA is the Family First Coronavirus Relief Act, which was one of the yes, right.
We know how versed you are in the policy. One of the things I wanted to bring up just really quick, and this has come up with several of my clients, it may have come up with your clients, but it's really in healthcare, is that with all of the PPP loans and everything that's come out, some people felt, and with the unemployment boost everybody got months ago, and looks like they're going to get again, it seemed like a lot of people would rather not work and get unemployment than come back to work. And then that was one thing. And so employers were having a really hard time getting people to come back because they were making more not working. And the second thing was that I had actually several in Ohio, Texas, and California is a different animal altogether, several physician practices that have been wanting to terminate employees and couldn't, but with the pandemic where they were furloughing people, saying it's really nice for me now because I don't have to bring them back. Yikes. I don't know what to respond to that.
Yeah, those are some great points, Terry. And that's what I was alluding to in mentioning the FFCRA. When employees do not want to come back, that is a reason for employers to terminate the employee and to say, okay, you're refusing to come into work, well, then we're going to terminate you. And that adds another layer of complexity because oftentimes you're going to have to do that over the phone or via email or by regular mail. And so you want to make sure that you do that correctly. And we've seen a lot of that due to COVID, where employees simply do not want to come back to work, or maybe there's an issue with childcare because their children are not in school, or their daycare is closed, or grandma and grandpa cannot watch the child. So we have had to walk our clients through several termination decisions with employees refusing to come back to work. And then to your second point, can employers use this pandemic to terminate employees that were really problem employees prior to the pandemic? The answer is yes, but they have to be very careful. They have to make sure that they're terminating them for the right reason. Are they terminating them because they are on a performance improvement plan? They're, low performing. They're not coming into work. We don't want to terminate them because, without documentation, because we risk, are they in a protected class? Do we have the documentation there to terminate them? Also, if these individuals qualify for any of the paid leave under the FFCRA, we want to make sure that we're not terminating them simply because they qualify for these benefits. So there's just a lot more to the analysis now because of the FFCRA, in addition to all of the other laws that we had prior to the pandemic. So we want to make sure that we check all those boxes when we're walking through the analysis.
Yeah, and I also noticed something that just came out recently, and this was more just an article I read, I think, in Becker's Hospital, about a lot of employers now want to require the vaccine, and if they don't have it, that they're considering that employee will be terminated. Now, obviously, that's a conversation for another day since it's not available to everybody, but definitely something coming up. Now, I know that your third scenario, and I'm excited about this, is how to terminate a contract employee, and also one that has a non-compete enforcement. So take it away. I think this is really great to this is our third scenario, and to complete on this.
Sounds great. Thanks, Terry. And that was a great way to segue into this scenario and to kind of set the stage. As you said, Terry, this is to terminate an employee who has an employment contract, and as a component of that contract may actually also have a non-compete agreement. You typically see employees that have employment agreements are typically doctors or other medical, highly licensed medical professionals. So this this type of scenario does play a lot into the healthcare realm. So with kind of setting the stage there, we're going to go ahead and jump right on in. Thank you for coming in today, Amanda. Please have a seat. The reason Rita and I scheduled this meeting is because our medical practice is terminating your employment agreement according to its terms by providing you with 30 days notice as required under your employment contract.
Wait, you're terminating my agreement? You know this company can't run without me. And I don't think that you're following the termination provisions, which are required in my contract. I'm going to have to talk to my lawyer about this.
I know this is hard news to hear. However, we have fully reviewed your employment agreement that you signed 2 years ago, and we consulted with our legal counsel on its terms. Further, as you know, we previously discussed that we believe that this is just not a good cultural fit. For this reason, as we are allowed to do under your employment agreement, we are terminating it without cause by giving you 30 days prior written notice. You will be permitted to work during the next 30 days, and we expect you to continue to work in accordance with the terms of the agreement.
So I have to work for the next 30 days. What's going to be expected of me?
That's a great question. We expect that you will continue to treat patients as you have done, while slowing down the number of patients you see each day as you get towards the end of the 30 days. We also expect that you will complete all patient notes and other records as are required under both your employment agreement and your state of Ohio physician license. We also ask that you do not disrupt the work environment or otherwise take any action that could harm the practice after your departure. Finally, we ask that at the conclusion of the 30 days, you simply return all company documents, including patient records, company equipment, and your key card.
That's a lot of stuff to remember. Well, I'm going to start looking for a new job right away because I'm not going to continue to work here under these circumstances. This is ridiculous.
You are permitted to seek new employment during the 30 days as long as such search does not interfere with your work requirements, and as long as you do not violate the non-compete provisions that are part of your employment agreement.
Whoa. What do you mean non-compete provisions? You terminated me. I'm free to do whatever I want, to go work for whoever I want.
I understand your frustration. As you will remember, when you executed your employment agreement, its provisions stated that you were not permitted to work for a competitor after employment with us within a 10-mile radius of our office. This provision remains in effect regardless of the reason for your termination.
Well, we'll just see about that. I don't think there's anything you can do about it.
Well, I just want to give you a heads up that we do intend to enforce the terms of the employment agreement that survive its termination, including these non-compete provisions. For this reason, we are going to advise that you seek guidance from your legal counsel as to your requirements under your non-compete and as you seek new employment. As I said, the practice will evaluate all legal recourse it may have to ensure that its business interests are protected.
Trust me, I'll be talking with my attorney, and you'll be hearing from them, as well as all of my demands regarding my rights under the employment agreement and this non-compete that you keep talking about.
We will certainly review any proposed changes to the non-compete or agreement that you or your attorney may have. However, we are not required to revise these provisions at this time. But like I said, we will review any proposed amendments as a courtesy to you.
Okay, fine. Are we done here? Because I'm done talking to you, Brian.
Yes, thank you for your time today, Amanda. We look forward to ending this professional relationship on amicable terms.
Well, that was awesome. I have a question on a contract termination with someone. Now, one of the things that wasn't mentioned is, do you tell that employee that they are not allowed to say anything? I know that said something there about you can't disrupt the practice or take any action, but are they allowed to speak to any other employee or even a patient if it's a healthcare about them leaving?
Yeah, that's a great question, Terry. So typically in the healthcare industry with an employment contract, there's going to be a lot of information that is in the employment agreement regarding, what you can say to employees, what you can say to referral sources, what you can say to patients, how do you need to wrap up your employment. And you heard Brian rattle off a list of, this is what you're going to do. And that was a verbal list. And I said, wow, that's a lot of stuff to remember. We would also give the employer client a written letter, because you heard Brian say this is, written notice of your 30-day 30-day notice of termination. So there would be a termination letter, and there would be bullet points of, this is the notice that's going to go to patients. Here's what you can say. Here's what you cannot say. You need to wrap up your medical records. You need to give us your key card. This is what you can say to other employees, what you can say to referral sources. And we're going to follow what's in that employment agreement. Typically, there's going to be, non-disparagement. There's going to be, return of any confidential information. They're not going to be able to access any of your software platforms or have email access or access to the EMR. So that's going to be enumerated in the written notice that they're going to take with them.
Got it. Yeah, I think the one thing that I guess stands out to me here, maybe I'm not sure if it even can be addressed, and this is more in a practice situation, not hospital, but a lot of times, especially in healthcare, and I think it actually probably is just about healthcare, a lot of patients, they tend to, when they find out somebody is leaving, they get pretty upset because they're so used to the routine of seeing somebody. They're already coming in distress for an ailment or whatever, and then if you've got an employee who's being let go, not leaving for their own reasons, I know that can add to some of the tension or whatever. And my concern is what I'm seeing a lot of, like Molina Healthcare and some of the bigger contracts out there with providers and their satisfaction surveys. It doesn't seem to be about the physician. It seems to be about a lot of times when employees leave and the patients miss them. And so I was just curious how that kind of makes a difference.
Yeah, I always advise the employer, and everyone does it a little bit differently, but it's always nice to have a backup plan. If you're going to give notice to your patients that an employee is leaving, and when I advise employers, I always make sure that in the employment contract, the employer, the hospital, the practice, the employer is the one to tell patients that the provider is leaving. And it's the employer that drafts the notice, that sends out the notice. And so it's the employer that's controlling the messaging. So along with that messaging, you want to have a backup plan so that patients know, we have a provider that's exiting, but we have all of these other providers that are able to care for you. Or we've brought on another provider to replace this individual to care for you. So you want to make sure that you have that plan in place as well. I have some employer clients that do this very, very well. And it really is a seamless transition. And patients feel very comfortable with the handoff because patients want to feel like they were considered in the decision and that they are being provided for. But some employers, they're not able to do that transition, or maybe the situation, warrants a quicker termination where they're not able to, have that ramp up period. Where they're able to get somebody in place. But employers, to your point, they really need to be thinking about the patient and making sure that the patient's taken care of.
That sounds great. And I appreciate the insight that both of you had on this. I know that these can be really kind of challenging situations, and how you handle it is going to be key to what the end result ends up being, and also how it could possibly fold into a potential next employee. So hopefully looking at this from a best practice and also past practices in similar situations can really help everyone. Well, I want to thank both Amanda and Brian. This was awesome and just truly informative of what we see in real life scenarios in employment termination. If you need to get a hold of them, you can go to their website at bmdllc.com and access them there. Also, Amanda is part of, again, the NSCHBC, and you can find a consultant at the nschbc.org. So again, we really appreciate having you. Everyone, thank you for listening today. Join us next month as we discuss virtual care in the new telehealth climate during PHE and beyond. and I'll be there with the American Telehealth Association rep. And then also in March, it's tax season, so we're going to get into some of the information as far as reconciling your funding, PPP, EIDL, HHS, etc. So everyone, make it a great day and a great week, and thank you for listening to the NSCHBC Edge podcast.
Thank you for listening to the NSCHBC Edge podcast. Join us on the second Tuesday of each month as our consultants tackle the complexities of navigating the business of medicine. You can reach us on the web at nschbc.org, the National Society of Certified Healthcare Business Consultants.